Hello, and welcome back to Terms and Conditions, a podcast by Con Maciel Carey. Here on Terms and Conditions, we discuss workplace laws in a grounded and accessible fashion to help you be an employer of choice. My name is Letitia Silas, and I am in the Con Maciel Carey office in Washington, D.C. Today, we are going to be talking about the importance of understanding how personnel matters impact merger and acquisition transactions. And for this discussion, we are joined by Victoria Zerjav. She is a partner at Cohen and Buckmann, which is an employee benefits and executive compensation firm located in New York. I am going to allow Victoria to introduce herself a little bit more and share more about her background. Welcome, Victoria.
Thank you, Letitia. I'm so happy to be here today. As you said, I'm a partner at Cohen and Buckmann, and I have been practicing in the area of employee benefits and executive compensation law for about 25 years, maybe a little more than that, but we don't want to talk too much about how much more. So I have also been working on mergers and acquisitions since the beginning. So it is very exciting to have a conversation about one of my favorite topics today.
I love that. So it's always a pleasure to speak with someone who loves what they do, especially when we're talking about the practice of law, right? Because sometimes it can be very dense and sometimes it can be very stressful. So I always love when I'm speaking with a colleague who loves what she does in this space. So, Victoria, why don't we start off here and just help us understand why are personnel matters important in M&A transactions?
Absolutely. Of course, I believe that personnel matters are very important, and I really hope that my clients believe and understand that as well. One of the things that makes personnel important is that most companies have employees. Most companies need employees to work on a day-to-day basis. And making sure that you have addressed the issues in a transaction, whether you're a buyer or a seller, in a manner that takes the needs of and promises previously made to the employees into account is going to be really important to have a smooth transition and to know that your business is going to be able to continue to function post closing. And sometimes there are unfortunate situations where there isn't the desire to have a employee transition, if you will. You don't want the employees, you can't afford to have them, but knowing all of the hiccups, the laws, and also the relationship issues that go with that becomes very important. I like this aspect of law, and it's very adjacent to what you do. One of the things I like about it is the human element. And so we get to think about people and how what is happening will impact the people, and it makes it very real. It's not just some elusive number. It's very real. It's impacting people's lives day to day.
That's really important because oftentimes when we hear of mergers and acquisitions, we might think of just a lot of paperwork. But you're right, Victoria, there are people involved, there are careers involved, and we have to be mindful of those when we are advising on these types of transactions. And you talked about maybe the purchaser may not want to take on the employees. Well, what does that mean for the seller? And in my world, well, what does that mean when the seller's employees may be represented by a union and covered by a collective bargaining agreement, but the buyer may not want to either take on those employees or may not want to adopt the terms of that collective bargaining agreement? And we're going to talk about that more as we move in our discussion here, but you're absolutely right. This is more than just numbers on a piece of paper. These are lives involved, relationships involved. And so it's really, really important that when we are advising our internal stakeholders, our clients, that we are mindful of those things as well, and we advise them accordingly. So, first off, Victoria, help us understand the different types of acquisition. So for this discussion, I really want to focus on the A part of M&A, the acquisition, when one business is purchasing another. Can you please explain to us the difference between an asset purchase and a stock purchase and the legal implications of each?
Sure. This is in some ways a very big question, and it's also, can be very much simplified. So there are two primary types of transactions, one being the acquisition of assets, where you are just buying things from a company, and that asset may be goodwill, which is not a tangible thing, but it's a thing. And the other would be a stock acquisition. Typically mergers falls into that as well, but where you are purchasing the equity of a company, and that pretty much says you're just buying the whole box. Whereas in an asset deal, you're picking things out of the box. In a stock transaction, you're taking the whole box with you, all of the good, the bad, and the ugly that go with it. You are you're taking it kind of as is, though the purchase agreement will dictate where there may be allocation of liabilities and risks. And in both matters, you'll see an allocation of liabilities and risks. But what that means, if I may go further, is that in an asset acquisition, employees, again, they're humans, and we don't just get to force people to move their employment. So we don't take the employees per se. There's going to be a situation where there is a termination of employment at one entity, their current employer, that is selling its assets. There's likely to be a termination of employment, I should say, because there's no longer, a computer for them to work on. The computer was sold. So then at a buyer, they're going to need to offer employment to that employee. And so it's not a business as usual, as you might expect with a stock transaction. You just keep going to work and doing what you did in your little box. Here, you have to step out of one box and go into another, and the box being the employer here.
100%. So that means the employees may actually be reporting to different managers, different supervisors. It is a different relationship. They are leaving one relationship and potentially entering a new relationship. Am I understanding that correctly?
Yes.
So that's really important as well when we're talking about if the employees are represented by a union or covered by a collective bargaining agreement, because you need to be mindful of what happens if the employment relationship on one end is terminated. What does that trigger under the contract? And then what obligations attach to what we call a successor employer, right? The new owner, once they take on that business. And if they hire some, most of, or all of the employees of the seller.
That's right. And, I should step back for just a moment on the union element, because in the first many years of my career, doing hundreds of transactions over my career, I did not see a lot of union activity. And in the sense of, representing a lot of private equity buyers, or even non-private equity. There might be VC investors. There were not as many companies with unions in this space and maybe it was just my experience, but I have seen a lot of this over the last 3 to 5 years that I hadn't seen before. And It may be just that the companies that have the employees that are covered by a collective bargaining agreement are becoming so attractive to buyers, or there has just been a door opened into that market. I can't I can explore, but I can't explain the reasons. But it has become something that we really do need to be sure to focus on from an employee benefits perspective, as well as from a union contract negotiation perspective. So I leave the union contract negotiation to you, whereas I would then address, okay, what now do we have to do? What do we want to do? What can we do with respect to the offerings of benefits for those employees that are covered by a collective bargaining agreement?
I agree. I've seen this more in recent years. I have had several of these types of matters come across my desk, and um, it is really important that the attorneys who are handling the transaction understand the labor implications. And unfortunately, in many cases, just generally speaking, in terms of what I've seen over my career, there isn't always an awareness or a full appreciation for the labor implications. And that can really hinder the deal. Because if a seller doesn't really understand what they are getting into, um, and then suddenly, maybe, and I've seen this come up, it's a week out from closing on the deal, and all of these things come up about the union and the collective bargaining agreement or agreements. The seller, may not have mentioned any of it, or may have, glossed over it because maybe they didn't think it was important. But now the purchaser has all this new information and may want to reconsider things because they may not want to take on some of those legal obligations, and they may have made certain statements or engaged in a certain type of conduct that might limit their ability to, for example, set their initial terms and conditions of employment with any of those predecessors' employees that they hire. So I'm seeing this more, and unfortunately, in the past when I've seen it, it's been really at the end of the game, right before closing, and now we're trying to really help the purchaser understand what they are entering into, so that they can make an informed decision, because this is going to be a long-term relationship, and it could be rife with a lot of disputes right from the beginning, in the form of unfair labor practice charges, information requests, work stoppages. So it's just really important that the purchaser understand what they're getting into.
Well, and that is where informing clients early on of the importance of employees and employee relations is very, I think, vital. And we need our colleagues who are, talking to the companies, the buyers on a day-to-day basis, to also recognize the import of, if there is a union involved representing some of the employees, let's get that information now. Let's get started learning what is going on now, so that you can address early enough in the transaction. People won't go down a line that they are not intending to. And it's not that the existence of a union is a game stopper anymore. It used to be in some ways, or in some industries for some purchasers. It's not a game stopper, but what it means is you need to stop and pay attention, because there is not the same amount of, I'll say, freedoms in designing those terms and conditions, as you mentioned. And from a employee benefits perspective, we really care. And we really, really care in a stock transaction. An asset transaction is somewhat almost more complicated, but just complicated. But in a stock transaction in particular, we worry about the types of liabilities that may exist under a multi-employer pension plan, not a 401k plan, but the traditional defined benefit plan, things that you heard a lot about in the 80s and 90s. And then there was this quiet in the early 2000s, and they're still there and they still exist. Um, and some are well funded, but some are underfunded. And it is that underfunding that is really what is material and important for a stock purchaser, because you mentioned successor liability earlier. In ERISA, for benefits, we focus on successor liability when it comes to defined benefit plans more than anything else, because that is where there are big dollars, potentially big exposures, and we want to make sure we have our arms wrapped around that as soon as we can.
Victoria, I love that you said that it's not always that a purchaser will kill the deal um, because there is a union. But it is important to understand what the tone and tenor of the relationship, existing relationship is, because you might be walking into a domestic dispute and there's a lot of acrimony there and a lot of history, and a purchaser may not want to be part of that. So it may not be necessarily the existence of a union. It may be, wait a minute, there's just been a lot of acrimony here, lots of unfair labor practice charges filed in the last 3 years, lots of work stoppages, strikes in the last 10 years or so, lots of grievances and arbitrations. You're looking at all of that, and a purchaser may say, you know what, this could be more of a battle than I'm willing to take on. I'm really looking for something that's a smoother transition or transaction than what we have here. Victoria, let's go into more of the employee benefits question. And when you are looking at these transactions, you are advising your clients. I know that you are looking at the type of benefits that are offered and what does that mean. Can you help us better understand that part of your analysis?
We are working on a transaction. We want to be sure that we are looking at really the world of employee benefits and compensation. So we want to understand all of the offerings to an employee. And so we're going to be covering a lot of different laws and a lot of different types of plans and arrangements. So the laws, what I tend to call the alphabet soup of these laws for benefits, includes ERISA and the tax code. People say IRC, COBRA, COBRA, for the post termination continuation of medical coverage. The ACA, that's the Affordable Care Act, and that's the law that came into place around 2010 in the Obama era, relating to the types of benefits that must be provided to or offered to employees for medical coverage. We have 401k plans. All qualified plans fall under 401a. We have, in a stock transaction, more focus on the 280G, which is another tax code section. And we also worry for compensation, executive compensation usually, but all employees are impacted by code section 409A around non-qualified deferred compensation. And then we have payroll terms. We have FICA, we have FUTA, we have Medicare. These are all these laws that we're going to be focused on. And that's not even state laws, right? That's just the federal rules we worry about. But then for the benefits, we focus on what are the pensions? Are there any pensions? Are there state laws that require pensions of some sort, of 401k plan or a contributory retirement arrangement, and what flavor is it? We will focus also on medical, or what people call health and welfare plans, which is medical coverage. Somebody offering a insured medical plan, is there a dental, vision, long-term disability, short-term disability, and life insurance, like group life insurance. There's also an array of supplemental plans that you're hearing a lot of litigation about lately in the ERISA world. And then there is also, we focus in a transaction. I focus on vacation. That tends to also be an overlap of my space with your space, but I focus on whether vacation is paid out upon a termination of employment. Is it accrued? And then there's bonuses, right? So we go back into then the compensation. There's bonuses. There's supplemental retirement. And then we also worry about equity arrangements. What types of special compensation arrangements are offered? Is it to all employees? Is it only to senior executives? So there are quite an array of things that we're looking at. And I haven't even gone into the subcategories of all of these. These are just the top level categories of each of these types of benefits.
And from an employment perspective, there are many laws that have to be considered as well, including FLSA, WARN, ADEA, ADA, in some cases OSHA, Title VII, and the equivalent state laws. You might also need to look at your Immigration Reform and Control Act obligations, especially when we're talking about a rehire by the purchaser, and whether there's going to be certain inspections required or prohibited, and by a collective bargaining agreement, right? So in addition to those other types of general employment laws in the labor space, of course, we are talking about the National Labor Relations Act generally, and we are now looking at the terms of the collective bargaining agreement. We're looking at provisions such as severance, successorship, layoff. Of course, we're looking at vacation and sick, because believe it or not, some CBAs actually have a provision that requires the employer to pay out sick leave upon termination. So you want to be looking at that. You also want to be looking at any notice requirements. So although in certain instances, perhaps a WARN notice isn't required, but the CBA may mandate certain notice, and the NLRA may mandate a certain notice in terms of how this is going to change the terms and conditions of employment for the impacted employees. And so that's just generally some of the big umbrella laws and issues, and now contract provisions we need to be thinking about. Victoria, what about when we're talking about employment contracts? Maybe individuals who are not covered by a collective bargaining agreement, but suppose you have some executive leaders or other types of professionals who have employment contracts.
Absolutely. We really focus intensely on those as well, especially, and I didn't use this phrase in my list of benefit plans, but severance. When there are severance provisions, you may have a group severance plan that applies to everybody, or you might have a special severance that someone has an entitlement to in an employment agreement, or some special commission arrangement, or just some other term of their employment. Maybe it's they have the right to work from home, and that's going to be a fundamental problem for the buyer. Maybe they have the right to use a vehicle, and that is, is or is not part of the buyer's policies. Things like that, which seem like fringe benefits, or some of these extra smaller benefits, because it's not applying to everybody, are actually sometimes some of the most expensive or administratively burdensome to handle. And that's actually an important element to focus on here as well. We don't only have, is the company itself complying with the laws? It's also, what is the company offering to the employees, so that we have employees that have certain expectations of what their day-to-day life is going to be when they come into work, and then others who have been given precise expectations in those employment agreements? And how will any of that need to change at the buyer because maybe the buyer can't afford to be as generous? Or maybe the buyer has never been able to or even tried to administer things like that before. So it's a variety of things. I think sometimes people think it is all about the money,
Yeah.
but it's much more complicated than that.
Yeah, absolutely. We're talking about helping our clients make informed decisions. And that's really, in my view, a three-pronged approach where there are legal considerations, operational, and financial considerations. So it's not just all about the money, it's all three of those things. And I put the employee personnel component under legal and operational because you need the bodies to do work, and then law, it could sometimes create barriers in terms of what can be done in that transaction. So I know we are always aiming to help our clients achieve their goals and either remove or neutralize the barriers that may exist.
I agree. I find that one of the most important things that we are doing here is just seeking the data, gathering the information, and putting it in a format that makes sense, that has meaning for those decision makers so that they can make their decision with all of the relevant pieces of information in front of them.
Absolutely. Now, when we talk about gathering all the data, this takes time. So I want to next talk about the pre-closing due diligence process. This, in my experience, should take no less than a month, and a month is short. And depending on the size of the organization, this might need to be happening 6 months to a year out. I mean, this is a really detailed, we're going to, look very closely at everything process. And you're collecting all this data, and there's usually a data room, and you're going through all of this data multiple times. And you are either answering questions or formulating questions based on that data. So, Victoria, could you explain to us the due diligence process and how far in advance, in your experience, before closing, should this be initiated?
Should this be initiated versus when is this initiated are very different things. So, wow, 6 months would be a luxury, or at
I
least
know.
knowing in advance that you, in fact, have 6 months is a luxury. I can't tell you how many times I get a call. Oh, we're closing, we're wanting to sign in 2 weeks, or
Yeah.
whatever the case may be. And oh my goodness. But if you have a full data room, you can do this, and you're physically capable of reviewing documents in a shorter period of time, but that's not what it is. It's about identifying what people have and being able to ask follow-up questions, get the answers, and break things down. And I think that's why we really want to have a longer period of time. In my world nowadays, if you have 2 months, it truly is a luxury, so that you
Wow.
can, yeah, you can look, and then you can ask questions, and you can have follow up. And I think people set um maybe not realistic expectations in the beginning of a transaction before they know anything. And then as issues are identified, it may just push things to, let's take a deep breath and figure this out. And so there may not be the push. Sometimes there is a business driver that forces you into a shorter period of time, which I find unpleasant because it inevitably leads to um, a situation where people, sort of disregard how important some of this information can be. They think, oh, well, we only have 50 employees. How important is this? But if those employees are a large cost of the company, or B, vital to the continuation of the business, it doesn't matter that it's a small number of employees. It could be meaningfully problematic if we don't know what we're addressing and dealing with. And And I agree. When you tend to have a company that has a union, a, a population that is covered by a collective bargaining agreement, you're going to typically see more employees. And that is where giving people more time to really dig into the relationship situation, look at relevant documentation, have, I'll say, casual interviews with relevant HR people, even if it's, I want to say, training your client, your buyer HR person, as to how to ask questions of the seller HR question, meaning like, what are the relevant questions? What are the important questions so that you can gather information? We have rules, as you know, that we cannot, as lawyers, just get on the phone or on the Zoom, whatever the case would be, with a seller's HR team without their counsel present. And that is something that people sometimes forget. And not lawyers. Lawyers know this, but their clients might forget, or, oh, this is just really efficient. But there's a process that we need to go through to make sure that the person on, representing the sellers in this case are not going to end up saying something without their counsel present, where they should, be told to not say anything, or things would be clarified. So we want to be sure nobody's put in a bad position. So we go through a process, and the process is just sometimes a little formal and burdensome, but that process also does help us to ask questions. So we'll get whatever we get in the data room to start with, and then we'll just say, well, what about this? What information is missing? But we'll also ask follow-up questions on the information that has been provided. So giving us more time helps us to have a good dialogue back and forth.
Absolutely. And I have to say, in my experience, 2 weeks out, if there's a union involved, is probably that is less likely to happen, because there may be certain things in the contract that certain provisions in the contract that require notice and a certain amount of time. Of course, the law may require some sort of impact bargaining, and how long does that take? And sometimes and this is from the seller's perspective, right? Sometimes the seller may not know or may not remember all of those parts of their contract, and sometimes the key executive team involved in the actual M&A transaction, right, who's actually talking to you, Victoria, they may not have negotiated the contract. The contract may have been negotiated by someone else in the organization, perhaps someone in HR or several individuals in HR, maybe outside counsel. And there may not be an awareness by these key officials now at this closing table, who will be at the closing table. They may not know all of these things that exist in this contract. And so, at least from a seller's obligations, there may need to be more time before closing that allows for more of the diligence process, and to actually take certain steps that are required under the contract.
I think you really hit a very important point, too, that also can create delays in transactions. But when people are trying to hastily do transactions, and that is the privacy element, or secrecy, where only the executives may know about the transaction. And so we won't have access to informed and knowledgeable individuals. And there are very important business reasons and legal reasons for needing to keep things confidential, especially if it relates to a public company, not wanting, to let the cat out of the bag. But wow, that definitely makes my life harder. I'm sure it makes your life harder as well.
And I've seen it. And it is important to remember that those who actually deal in the personnel matters day in and day out are going to be the individuals who have the information you need to help this transaction go quicker and more smoothly. So, although you might want to keep a very tight circle in terms of those with a need to know basis, right? But you are going to want to make sure that you are engaging with the professionals within your organization who actually have their hands on the employee benefits, on the employee handbook, on the collective bargaining agreements, if any, on a regular basis, because they are the ones who will be able to point you to things that you have to think about in this process. So, Victoria, why don't we next talk about those key organizational leaders who should be involved, who may have, like I explained, a need to know in this transaction?
Well, typically you'll have a business side deal team lead. And, if you have a public company, they may have a team that's involved in every transaction. And so you may have a situation where no one else in the business knows. So who do I care most about? I think that there are two key roles for me. Number one, it is the CFO or the financial lead for the business, as the case would be, the one who knows whether you are reporting liabilities on your financials. That's really important to look at, because that helps us to understand what do you already know is out there. And also for a small company, your CFO has to wear a second hat, and that's my second person, your HR lead. Now, sometimes your HR lead is also your benefits leader, but making that person available or looping them in is very helpful, because they also see all of the relationship issues, if any, with the employees. They see where the struggles may be on a benefits, administration perspective, usually as well. And I say usually because, again, it depends on the size of the company. A company with 10 people altogether, you might have all of this bound into your CEO. But a company with 10,000 people, this may really be 6 or 7, but you can only pick 2 or 3. But there are ways to get information if you at least can have a team leader seeking to gather information or being willing to support getting some detailed information on no names basis.
And what role is counsel playing, whether that's in-house counsel or outside counsel?
Well, the in-house counsel, I would expect in this area, as far as the in-house counsel that is responsible for employees, should be making, I would think, planning in advance. This is from a seller perspective, planning in advance for where there are any issues, again, with the employees, any concerns relating from their benefits or their HR team that have already trickled up. And then they could even, again, investigate whether there are any concerns that they should be having. It is a company that is going to be large to already have an in-house employee lead counsel. But as a buyer, I think it's very helpful when that same role is able to identify what the expectations of the buyer is, where their limitations are as far as what terms will we offer, what terms won't we offer, and why not. Because so many times we have little things, if I may digress for a moment.
Please.
In employee benefit plans or arrangements in transactions, one of the biggest things we focus on is how the 401k is going to be treated. And you're a lucky company if that's the biggest problem that you have, right? But what we worry about is, will the 401k plan continue as it is from seller to buyer? Or does the buyer already have a 401k plan and it wants the new employees, even though you're sending the whole box over, right? It may want to have those employees integrated into their benefit plans early on. There's a special nuance with these types of plans where you have a limited window if you want to terminate the old and transition to new. So that's one of the things we focus on. And I have actually had an arrangement or situation in the past where I was not given access as outside counsel. There was no in-house benefits person, but the business leads said, "Oh, no, I think it's fine to continue the 401k plan." And I said, "Are you sure? Are you sure? Like, this really matters to your benefits people because they have to administer this. Are you sure?" No, we are sure. We're going to go with this." And 4 months later, after the transaction, I get a call from their HR person saying, I don't know what to do. And they had a particularly interesting situation that's becoming more prevalent today, where they use these new types of plans where we basically have to ask for blessing to merge the plans, which is the real only option at this point. And so it was difficult because we missed a window to address a situation that you really want to address and make sure the relevant parties are involved in pre-closing. And that can get really hard. But some companies, going back to where I started here, some companies will have an in-house counsel that says, "I know our policy. Our policy is X." And they know that if they want to diverge from that policy, they need to get approvals from certain people, and otherwise deal with the wrath afterwards. I say jokingly, tongue in cheek here, but to deal with, this is not the policy, this is not the practice that we want to do. Anyway, those individuals having involvement early on and weighing in is very helpful, because it also signals to us, outside lawyers, who will be not only looking at diligence, but drafting purchase agreement provisions, whether it's the representations and warranties or the covenants. We want to make sure that we understand what are those push points for our clients, what are the issues that they have addressed in the past and they don't want to deal with anymore. And we want to be able to hit those points, and having the information from the client is very valuable. And it's not because we only focus on the things the client cares about, but it's because there are, thousands and thousands of issues that could be addressed in every transaction. But in reality, you can't do that. So if this client is not concerned about what the benefits looked like before, because we are terminating them all pre-closing, they worry about some other element of the transition, like, we want these employees to immediately start on our vacation plan. That's an issue we have to deal with and we have to maneuver through. And so we're going to focus on that one, because now we know we can tick the other boxes and we don't have to worry about them.
Exactly. Or where the client may say, well, we want the employees to be on our ESOP plan, but they're already covered by the union's pension plan. So what does that mean? And we're talking about potentially withdrawing from that pension plan. As you know, that can cause a lot of acrimony, a lot of issues, and legal battles along the way as well.
Yes, withdrawal is a very scary or expensive word.
It is very, very much so. So, Victoria, just quickly, I'm going to breeze through some other things that I think we want to help our client at least have an awareness of as we are doing the diligence process and looking under the hood, so to speak. And as you noted, I tend to think that our job as counsel is we're trying to issue spot. The client might be okay. They might say, you know what, thank you for bringing that up. Um, I'm okay with it, or I don't want to go in that direction. I want to go in this direction. But I think they are relying on the lawyers to issue spot the legal issues and tell them what their rights and obligations are and what their options are, right? And then they can make an informed decision based on that. So I think they really rely on us to point things out that may not be readily apparent to business people who are not looking at things from a legal lens.
You're absolutely right. We do need to focus on the population, how many people there are, whether they are subject to a collective bargaining agreement. And I also like to focus on where they are, because that helps us with, particularly with the unions, some of the state laws that would apply.
Absolutely. And also the demographics, the EEO demographics, because part of this may require a disparate impact analysis. If we're talking about layoffs or terminations, and individuals are not going to be rehired after the transaction closes. What about compensation structures? I have that down. Bonuses, commissions, equity. Can you talk about that?
I think, well, equity in particular is one of the important things to focus on, because the equity arrangement that you have prior to a closing, even as an asset transaction, or especially as an asset transaction, is not going to apply in the post-closing world. So you're going to have usually a cash out or some sort of treatment or a point in time where we have a shift with respect to the equity. And a lot of times, if there is some accelerated vesting or payout of benefits in connection with the transaction, this implicates our 280G, which is often called the golden parachute rules. For compensation structures, one of the things that we focus a lot on is, in my experience, buyers will agree that they won't mess with the base salary, but maybe bonus opportunity might change. Commissions, that is something we often look for some treatment or acknowledgement of the ability to continue the same commission arrangements, because that can also be a challenge where people may have done most of or all of the work necessary to earn a commission. When is that going to be paid? That is something that we really need to focus on to make sure that we are not impermissibly taking something away when we change the arrangement.
That's right. That's right. Just a few other things that we've already talked about. We're looking at the employment agreements. Are there actual employment contracts in place, or a collective bargaining agreement, or is this completely at will? We're looking at restrictive covenants. We're looking at pending or past employment and labor litigation. And I'm also including agency charges in that. We're looking at workers' compensation and disability claims. And just on that topic of restrictive covenants, Victoria, can you talk about that a little bit, and what if there are non-competes involved here?
I find non-competes to be a very challenging area, in the sense that in all of this, there is no one size fits all. But usually, if somebody has a restrictive covenant and you buyer are buying all of the stock, business as usual. Again, it just continues as it was. But when you're buying the assets, you may need to be sure that the seller can assign that right to you as the buyer, or that you're going to be getting some other new protection. And also that the seller is not going to claim that you employing this individual after the transaction is going to breach the restrictive covenants. So in some ways, it's an opportunity for a buyer to redefine, to enter into new, different restrictive covenants. And certainly with transactions, sellers themselves, the founders and the major owners of a company, they have a different type of restrictive covenant they may be asked to enter into in connection with the transaction itself. But keeping in mind that if the founder is also going to be an employee post closing, there's a lot of not lines, but areas that get crisscrossed here, right? So you may have a restrictive covenant that overlaps with an employment related restrictive covenant. So your transaction restrictive covenant covers some period of time, and your employment covers another. And are you even physically in a state that would enforce that restrictive covenant?
Mm-hmm.
Different companies take different perspectives on the treatment of the restrictive covenants and their comfort level with being aggressive with restrictive covenants. And so that's where it's going to be different for every client in their approach. But it is one of the highlights, if you will, or the high level issues that we will want to focus on.
Absolutely. And I'm glad you mentioned that jurisdictional question, because in some jurisdictions, the restrictive covenant in the form of a non-compete is only lawful with respect to individuals at a certain income threshold or salary threshold. So you also need to be looking at that jurisdiction question. Where are you? Is this something that's enforceable? Was it lawful to begin with? Because I find that sometimes there are these agreements in place and it runs contrary to the law, but whoever drafted the agreement didn't really know that. And maybe the law changed all of a sudden. And what does that mean for those individuals and for the organization? Quickly, Victoria, what about employees working under a visa?
Employees working under a visa is generally, again, with a stock transaction, going to be smoother because they
Mm-hmm.
haven't had a change of employment, and you don't need to report that the employer itself has had some sort of a change of control. But employees working under a work visa and in an asset transaction, you actually do have a big issue to consider. I'm not an immigration attorney, though, so unfortunately, I have to defer a bit to others.
Yeah.
I can simply share that because of the change of employment, you do need to be more conscientious. You need to plan ahead. And now, with some of the changes to our immigration laws over the last year or two, this may actually impact your ability to retain that employee.
100%. And I'm so glad you just deferred to immigration counsel. That's something that is key in being an attorney. You have to know your wheelhouse. You have to know your lane. What we do is issue spot. We're able to issue spot a lot of things. It doesn't necessarily mean that we're an expert in every single thing we can issue spot. We're an expert in our area of practice that we will often tell you. For me, it's labor and employment with a very strong emphasis on traditional labor. For you, it's employee benefits and executive comp. But we are able to spot, hey, and inform our client, hey, this is something that stands out to me, and you might want to consult with immigration counsel or whatever the appropriate counsel is. Let's just say withdrawal liability, a counsel that handles that type of work. So I'm glad you said that, because too often there's a guessing game that happens, and you got to be comfortable with saying, I that's not my wheelhouse. I know that that's an issue, but let me connect you with my colleague who is an expert in this and can help you in this. So
Yes, and the more that others appreciate that as a possible issue, the more helpful it is for all of us to know that we can't all be experts in everything and accept that we need to pull in someone else for help.
absolutely, absolutely. I mean, it's the same thing when I sometimes compare this to the practice of medicine, right? If you have a specific issue, you go to a specialist for that. You're not going to your general for that. You're going to the specialist. Your PCP will send you to the specialist that deals in that particular thing, because the PCP may be able to generally identify that there's an issue there, but not necessarily on that unique type of an issue. So same type of thought process applies here. So, Victoria, I think that we are almost at time here. We've had a very good conversation, but I do want to leave our audience with some best practices that they should consider when their organization is embarking on this journey to acquire another business or sell their business.
I think some of the best practices would be around being aware of the issues that can occur and being prepared to deal with them. As we started talking about early on, is that involving labor and employment and benefits so late in the game can be, or too late in the game can be problematic. So being open to involving your benefits team earlier on is usually very beneficial, because we can ask some questions early on that may change whether you even want to pursue the transaction, or also give you comfort that you don't need to be as worried as you may have thought you would be. But identifying the type of transaction is really number one. The type of transaction, the value of the transaction, I think, is very important. The number of employees and the location of the employees, like we just talked about, is some of the first pieces of information I need to know to put you into an initial bucket of what is the potential scope of the liability, right? If we're talking about a place with 10 employees, the likelihood of needing to deal with about 15 different benefits related laws just drops off the table. So that is very important. Don't hide information from your counsel would be one other piece of information. I think people get embarrassed about making mistakes, or they get nervous about some fact that's out there, and hiding that from your counsel can be one of the most challenging things, because things like this do eventually come out, and your counsel is there for you to help you as an organization to manage and address the issues that are in front of you. So hiding things is not meaningful, and it doesn't save money or time at the end of the day. I think sometimes people say, "Oh, I don't want to burden you with that. I don't want you thinking about this or worrying about this." But knowing the facts is really, really important to be able to get a complete answer or a complete issue list.
I agree 100%. I think that's a great note to leave out on. Share information with your counsel, keep your counsel informed, hold hands with your counsel. We work for you. When you've hired us to represent you or advise you, counsel you, we work for you. Our job and our goal is always to serve your best interest, to keep you informed, to advise you appropriately. So giving the more information you can share, the better. I think the better your counsel will be able to serve your best interests and help you make the decisions that accomplish your goals and help you strategize to either remove or neutralize certain barriers that are in your way. With that, everyone, I thank you again for joining us on Terms and Conditions. I am Letitia Silas. I am a labor and employment attorney here at Cohen and Buckmann. We are headquartered in Washington, D.C. For this conversation, I was joined by Victoria Zerjav, a partner at Cohen and Buckmann, an employee and executive compensation firm in New York. Thank you so much, Victoria.